Thank you, Caroline, and welcome everyone to the first panel of the morning. The topic, Text, History, and Principle, What Our Constitution Means and How to Interpret It. Thank you all for being here, and thanks especially to this distinguished panel that has been getting all sorts of high expectations and early rave reviews. So I hope that we can actually explore constitutional interpretation, how the principles play out in a way that brings it all down to earth, but also involves all of you in the discussion as we go along. A little bit about how we're going to proceed. Obviously, we're going to be addressing the topic of constitutional interpretation, but using as our launching pad Jeff Stone's essay on this whole panel was the brainchild of Jeff, and he has some strong views about how conservatives have taken over this debate and what the challenge is for progressives. So what's going to start first is Jeff will present his thoughts on this, and then our four panelists will do some initial responses just so we can see the lens through which they see this debate and the different roles they come to this from. We have two distinguished judges, Judge J. Harvey Wilkinson from the Fourth Circuit in Richmond, Judge Diane Wood from the Seventh Circuit in Chicago. We have Stanford University professor Pam Carlin and Yale University Law professor Akhil Amar. They all have very extensive biographies that you'll see in the materials. As I said, they will first respond to Jeff, and then we're going to have a conversation up here that we hope toward the end that you will join. And as you know, you have some cards on the table that you can write down some questions. There'll be people waiting to collect those in time. A few bookkeeping things first about the what you need to do to get credit if you want your CLE credit for this. Sign in at the attendance record at the CLE desk outside this room. Pick up your certificate of attendance and fill out the evaluation form at the end. Also know that since this is being taped and we're trying to stay on time, it would be good to be ready to ask those questions, and also to make sure all your cell phones are off because it is being taped. We want to thank especially Sussman Godfrey, which is the sponsor of this panel, and again, because it's leading off, we feel like this is a good one to set the terms for some of the debate that's going to unfold over the next 2 days. We're going to explore the states of constitutional interpretation, how principles play out in rulings, how they influence the political discourse, and how they affect life on the ground. Specifically, we'll be addressing the enormous influence of originalism that's now taken over some of the debate, and whether it's an approach that truly affects a jurisprudence or, more accurately, a political ideology. And along those lines, I just want to mention, going to the panelists we have, that defining the originalism is just the start of the argument, not the finish, because we actually have two people up here who can defend originalism, but not in the way that it's currently practiced by some of the justices on the Supreme Court. So they all come to this question with different approaches, and we hope to examine what might be particularly driving theories and the most effective way, as I say, for people in this room to become part of the debate and influence the public's understanding of competing views of constitutional interpretation. And I encourage our speakers to try to take these abstract principles of constitutional interpretation and bring them down to a more concrete level, and maybe even in the context of some of the issues of the day, including the healthcare legislation, same-sex marriage, and reproductive rights. So with that, we'll start with Jeff Stone and then go on to our responses. Thank you all very much.
Thank you, Joan. I should say as a preface that the remarks I'll give here are the product of work I've done with Bill Marshall, who is a professor at North Carolina, a former member of the board of ACS, and chair of the program committee of ACS. So you should blame Bill. For the past 40 years, political conservatives have effectively framed the national debate over constitutional interpretation. According to the conservative narrative, their approach to constitutional interpretation adheres to the true meaning of the Constitution, whereas liberal jurisprudence is concerned only with achieving specific desired outcomes without regard to the text, history, or meaning of the Constitution. The gains that conservatives have achieved by characterizing the debate in this manner cannot be overstated. Because the public has generally accepted the conservative account, Republican presidents have been much more aggressive than their Democratic counterparts in appointing judges with strongly ideological inclinations, and constitutional doctrine has moved sharply to the right as conservative jurists have become ever bolder in their pursuit of politically conservative outcomes. The conservative constitutional narrative is deeply unprincipled and patently wrong, both in its defense of conservative judicial ideology and in its attack on what conservatives deride as a result-oriented liberal jurisprudence. In fact, most of the decisions the conservatives deride are premised on sound principles of constitutional interpretation and on the framers' own understanding of our Constitution and of the essential role of courts in our constitutional system. But although progressives actually hold the high ground in this debate, we have failed in public discourse, both to unmask the realities of conservative judicial methodology and to explain the logic, legitimacy, and coherence of our own understanding of constitutional interpretation. Unless we take up this challenge, we will continue to lose in the courts, in nomination battles, in the legislatures, and at the polls. It's time for ACS to take up that challenge. Now, to begin with first principles, it's necessary to affirm at the outset that the framers of the American Constitution were visionaries. They designed our Constitution to endure. They sought not only to address the specific challenges facing the nation at the time, but also to establish the foundational principles that would sustain and guide the new nation into an uncertain future. The text of the Constitution clearly reflects this vision. It defines our most fundamental freedoms in general terms: freedom of speech, due process of law, free exercise of religion, equal protection of the laws, cruel and usual punishment. These phrases are not self-defining. The framers understood that they were entrusting to future generations the responsibility to draw upon their intelligence, their judgment, and their experience to give concrete meaning to these principles over time. As Chief Justice John Marshall observed almost 2 centuries ago, we must never forget it is a constitution we are expounding, intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs. This understanding reflects an approach that is true to what we might call the framers' Constitution. It recognizes that the Constitution sets forth broad principles and that a central challenge of constitutional interpretation is to define and then to give life and substance to those principles in an ever-changing society. The principles enshrined in the Constitution do not change over time, but the application of those principles must evolve as society changes and as experience informs our understanding. American constitutional law has, in fact, long followed the path set by Chief Justice Marshall. As technological means of surveillance became more sophisticated, the meaning of search in the Fourth Amendment came to include invasions of privacy, like wiretapping, that do not involve a physical trespass. The provision granting Congress the power to maintain the nation's land and naval forces was eventually seen as authorizing an air force. The guarantee of equal protection of the laws came to be understood as prohibiting discrimination, not only against African Americans, but also against women. Commerce among the several states came to be seen differently as the nation's economy became ever more complex. And the concept of liberty came to encompass not only freedom from physical restraint, but also freedom from undue government intrusion into fundamental personal decisions. But how should we give content to the open-textured provisions of the Constitution? On the one hand, judges must have sufficient authority to enable our constitutional liberties to remain vital and to endure over time. But on the other hand, judges should not have such broad authority that they can freely substitute their own personal values for those of the people. The best solution to this dilemma, which is grounded in the vision of the framers, has a long and honorable tradition in American constitutional law, and it has essentially two elements. First, at the very core of the framers' Constitution is the recognition that in a self-governing society, courts must generally defer to the preferences and judgments of the majority. Although courts may always review governmental action to guard against arbitrariness and unreasonableness, the starting point must be a presumption of judicial restraint. This is an essential tenet of any principled theory of constitutional interpretation. It is not for the judiciary to run roughshod over the judgments of the democratic process. But second, respect for the framers' Constitution requires us to recognize that although the framers thought majority rule to be the best system of government, they knew it to be imperfect. They understood that political majorities may be tempted to enact laws that entrench their own authority, and that prejudice, hostility, and intolerance may at times lead governing majorities to give short shrift to the legitimate needs and interests of political, religious, racial, and other minorities. The framers intended courts to play a central role in addressing those concerns. When proponents of the original Constitution argued in 1790 that a Bill of Rights would be pointless because political majorities would simply ignore those guarantees, Thomas Jefferson responded that this argument failed to consider the legal check that could be exercised by the judiciary. When James Madison faced similar objections when he introduced the Bill of Rights in the first Congress, he maintained that independent tribunals of justice will consider themselves the guardians of those rights and will be naturally led to resist every encroachment upon them. And in Federalist 78, Alexander Hamilton stated that constitutional protections and limitations could be preserved in practice no other way than through the medium of courts of justice, which must guard the Constitution and the rights of individuals from the effects of those ill humors which sometimes disseminate among the people. This understanding of the framers' Constitution found expression in the modern era in a series of Supreme Court opinions in the 1930s and 40s. Most notably, in the court's famous footnote 4 in Caroline Products, decided more than 70 years ago, the court suggested that there are some circumstances in which there may be narrower scope for the usual presumption of constitutionality. Specifically, the court noted that more exacting scrutiny may be appropriate when legislation restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation, and when laws disadvantage groups like religious or racial minorities because prejudice against such groups tends seriously to curtail those political processes ordinarily to be relied upon to protect us from injustice. Put simply, the court in Caroline Products recognized that courts should not defer to the outcomes of the political process when there is good reason to believe that that process itself may be tainted. Following this approach, the Supreme Court has properly departed from the usual presumption of judicial restraint when governing majorities disadvantage historically vulnerable groups, such as African Americans, ethnic minorities, political dissidents, religious dissenters, women, and persons accused of crime, and when they use their authority to stifle their critics or entrench their own political power. In such circumstances, it is proper and necessary for courts, Madison's independent tribunals of justice, to exercise a more exacting judicial scrutiny in order to guard against those malfunctions of majority governance that most concerned the framers. And this, too, is an essential tenet of principled constitutionalism. Invoking this understanding of judicial responsibility, the Supreme Court has issued a long series of landmark decisions over the years that faithfully interpret and apply the framers' Constitution. These decisions ended de jure racial segregation, recognized the principle of one person, one vote, forbade government suppression of political dissent, established an effective right to counsel for persons accused of crime, struck down government discrimination against women, limited the authority of government to interfere with women's reproductive choices, and upheld the right of enemy combatants to due process of law, to offer just a very few examples. These decisions animate the most fundamental aspirations of our Constitution in circumstances in which judicial intervention is not only proper, but necessary. For the past half-century, however, conservatives have argued that the Supreme Court went too far in the 1950s and 60s in its efforts to preserve the vitality of self-governance and to protect the rights of those most in need of judicial attention. In the late 1960s, for example, conservatives like Richard Nixon and Strom Thurmond vehemently condemned what they derided as the Warren Court's judicial activism and called for the appointment of judges and justices committed instead to aggressive judicial restraint. But although judicial restraint in appropriate circumstances is essential to principled constitutionalism, its sweeping reflexive invocation would abdicate a fundamental responsibility that the framers entrusted to the judiciary and would therefore undermine a critical element of the American constitutional system. It is no more appropriate for judges to refuse to enforce the Constitution against intolerant or self-perpetuating majorities than it is for the president to refuse to defend the nation against enemy invasion. Perhaps recognizing that a theory of unbounded judicial restraint is constitutionally irresponsible, conservatives next came up with the theory of originalism. First popularized in the early 1980s by Robert Bork, Edwin Meese, and Antonin Scalia, this version of originalism presumes that courts should exercise judicial restraint unless the original meaning of the text clearly mandates an activist approach. Under this theory, for example, it is appropriate for courts to invoke the Equal Protection Clause to invalidate laws that deny African Americans the right to serve on juries, but not to invalidate laws that deny women that same right, because that was not the original meaning of the Equal Protection Clause. Originalism, however, is fundamentally flawed. First, because those who enacted the broad foundational principles of our Constitution did not, in fact, have any precise and agreed-upon understandings of the specific meanings to be attached over time to such phrases as the freedom of speech or due process of law or regulate commerce among the states, it is exceedingly difficult to know with any certainty, as historians will attest, what they actually did or did not think about concrete constitutional issues. As a consequence, judges purporting to engage in originalist analysis generally project onto the framers their own personal, religious, social, and political preferences. In the absence of any real evidence of original meaning, they tend to reason as follows. The framers were reasonable people. I'm a reasonable people. The framers must have intended what I would have intended. And there it is, original meaning. The result is an unprincipled and patently disingenuous jurisprudence. There is simply no evidence, for example, for the claims advanced by conservative jurists that the original meaning of the Equal Protection Clause prohibited affirmative action, or that the original meaning of the First Amendment guaranteed corporations a constitutional right to spend unlimited amounts of money to dominate the election of public officials. Yet these are central precepts of the conservative originalist agenda. The second problem with originalism is even more disqualifying, for it reveals the theory to be internally incoherent. Originalism asserts that those who crafted and ratified our Constitution intended the meaning and effect of their handiwork to be limited to the specific understandings of their time. But this view erroneously attributes to the framers a narrow-mindedness and short-sightedness that belie their true spirit. As Justice Louis Brandeis observed more than 80 years ago, the framers believed courage to be the secret of liberty. The framers were not timid men. As men of the Enlightenment, they believed that just as reason, observation, and experience would enable us to gain greater insight and understanding over time into questions of biology, physics, economics, and human nature, so too would they enable us to learn more over time about the content and meaning of the broad principles that they had enshrined in our Constitution. Indeed, the notion that any particular moment's understanding of the meaning of the Constitution's open-ended provisions should be locked into place and taken as constitutionally definitive would have seemed completely wrong-headed to the framers themselves, who held a much bolder and more confident understanding of their own achievements and aspirations. For these reasons, the conservative doctrine of originalism has been largely discredited, apart from a few Supreme Court justices and scholars, as a serious method of constitutional interpretation. This is not to say that the views of the framers are irrelevant. To the contrary, their values, concerns, and purposes, as reflected in the text of the Constitution, must inform and guide the process of constitutional interpretation, but in a sensible manner. They must be considered as the framers themselves understood them, as a set of general principles and aspirations, rather than as a collection of specific and short-sighted rules. To be true to the framers' Constitution, we must strive faithfully to implement the framers' often far-sighted goals in an ever-changing society. That is central to any theory of principled constitutionalism. We've now entered a new and even more troubling phase of constitutional conservative jurisprudence. It's best characterized as conservative activism. Justices who readily dismiss constitutional claims today by women, political dissenters, persons accused of crime, and racial, ethnic, and religious minorities, but at the same time aggressively strike down affirmative action programs, gun control laws, restrictions on corporate political expenditures, regulations of commercial advertising, federal civil rights laws, and the laws of the state of Florida in the 2000 presidential election, have hijacked the power of judicial review. Conservative justices today exercise that authority in a highly selective and politicized manner that cannot credibly be explained or justified by any principled theory of constitutional interpretation. Indeed, despite all the conservative bombast about originalism, strict construction, judicial restraint, applying rather than making the law, and calling balls and strikes, this pattern of decisions raises grave concerns about the considerations that actually drive the jurisprudence of our conservative justices. In the end, of course, despite what the conservatives say, constitutional interpretation is not a mechanical enterprise. It does require judges to exercise judgment. It inevitably and properly calls upon them to consider text, history, precedent, values, changing social, economic, technological, and cultural conditions, and the practical realities of the times. But above all, it must be grounded in the judiciary's unique strengths and in a proper appreciation of the most fundamental reasons for judicial review. Courts must have the authority to invalidate acts of the elected branches of government, not so that they can pursue a conservative or a liberal agenda, but so that they can serve as a check on majoritarian dysfunction. This understanding has long and rightly been central to the progressive understanding of constitutional law, and it is the right understanding of constitutional law. It is time now for a new era of principled constitutionalism. It is time now to return to the framers' Constitution. Thank you.
We're just going to wait a minute while they remove the lectern here. Thank you, Jeff. That's a great way to launch. Very provocative discussion here. As I mentioned in my opening remarks, all of our panelists come to this debate from different positions, but also different ideologies. And I thought it'd be good to start with Judge Wilkinson, who I'm sure proudly wears the label conservative and is no Jeff Stone, but who agrees with some of these principles. And I just want to mention one thing that he wrote that many of you might be familiar with back in 2009, right after the Heller decision at the Supreme Court. In a vigorous and highly critical analysis of some of Justice Scalia's approach in District of Columbia versus Heller, Judge Wilkinson compared it to Roe versus Wade and said each represents a rejection of neutral principles that counsel restraint and deference to others, regardless of the issues involved. And I thought we'd just start with you in a brief response, Judge, to some of what Jeff said and what you'd like to talk about, where you come from.
Well, Jeff, thank you very much, and it's a pleasure to be here as always. I certainly appreciate the warm hospitality I've been shown. My chief concern is that I'm thinking that we're living through what I would call an impoverished area of constitutional law. And I thought to myself, wouldn't it be exciting if in our day and time we had the sense that we were really seeing an era of constitutional law akin to that of the Marshall Court or the early days of the Warren Court, which 50 or 100 years from now people would look at as a great apex of this discipline. But as Joan mentioned, I think the gateways to our modern era of constitutional law, or the brackets, are Heller and Roe, and I think that they're both deeply, deeply flawed decisions. And Heller, the preamble to the Second Amendment, proved inconvenient, and it was just cut off and dismissed and shipped out to sea. And the majority started traveling through time and space and going, asking what the Stuart Kings were doing in England, and then it went 100 years past the founding event and past the Civil War to ask what the enactment of the Second Amendment meant. It predictably is going to involve the courts in all kinds of minute decisions about the minuscule characteristics of this and that gun. So I thought it was a very badly flawed decision. I also think Roe is a very badly flawed decision. Go read the opinion sometime. It's going to strike you as a terribly drafted statute. You may agree with the result, but the methodology is simply not there. And then when the court followed it up with an undue burdens test, that itself was going to involve the judiciary and all kinds of details. And the undue burden test was almost designed to transform courts into legislatures. So, we have these dueling versions of activism. That's our day and time. And is that really what you want? I don't think I would be on a wild ride of speculation if I said some of you in this audience are not great fans of Citizens United. And I don't think I'd be running off the rails if I said some of you in this audience, just a few, might not love Bush v. Gore. And there may be another person or two who's not crazy about the Seattle and Louisville school decisions. So you might want to, there's a temptation to live past successes. But you might want to think, rather than promoting a robust role for the courts, maybe it's time for a more liberal version of restraint. Because things are happening that that some of you are not comfortable with. And so the question is, can you credibly critique decisions like Citizens United and parents involved if at the same time you're embracing unenumerated rights on issues like abortion and same-sex marriage? It makes it very hard to launch a persuasive critique of conservative activism on the one hand and embrace unenumerated rights to the extent that has happened in others. And none of this involves relinquishing a commitment to choice or to same-sex marriage. It simply involves an openness to achieving aims through the political process, to realize that questions like abortion and same-sex marriage are very, very difficult. And the arguments on each side are worth listening to, and they are weighty arguments, and it's just not something that can be, one side can win with a slogan. And maybe the best way to achieve these aims is through the political process, not through constitutionally. Some of these gains that you want are going to require democratic assent to be enduring. And so I wonder, rather than dueling models of activism, which Rowe and Heller gave us, can we not return to dueling models of restraint? And that's my challenge, and that's what I would ask you to at least talk about and think about a little bit. This doesn't really matter. It doesn't really ask you to give up anything you believe, but just ask really what, in the long run, is the best means of achieving it.
Thank you, Judge. Pam Carlin, you're distinct on this panel as someone who actually litigates fairly regularly before the Supreme Court. And I was wondering, given that perspective, how you think some of these ideals play out on the ground, and what would you say to Judge Wilkinson's idea of a quest for a more liberal version of restraint?
Well, I'm sitting here between Judge Wilkinson and Jeff Stone, and I feel like the child of divorcing parents who wants to agree with both of them. I want everybody to love me. So here's the thing. I want to start by just saying the constitutional moment that has meant the most to me in the last year came out of something that probably most of the people in this audience rolled their eyes about, but that I found intensely powerful. And that's at the beginning of the House of Representatives session in January. You know, the House got up and they read the entire Constitution out loud. And I know well, they didn't read everything because there were some parts that were inconvenient, but they read most of it. But the moment that I found the most powerful in that entire episode was when John Lewis, the congressman from Georgia, got up to read the 13th Amendment. Because when we talk about the framers' Constitution, I think of John Lewis as one of the framers of the 13th Amendment as we understand it, and one of the framers of the 14th Amendment as we understand it. And that's the part of me that agrees with my good friend Jay Wilkinson, which is, if we ask what has brought equality to America today, what is the most important thing that has brought racial justice to America today? It was not the Supreme Court's decision standing alone. It was the Second Reconstruction Congress and the ways in which it legislated. That is, the ways in which the people and Congress felt that the Constitution in some sense permitted, but in other senses compelled them to bring real equality. The Voting Rights Act registered more African Americans in the 2 years after it was passed than the 15th Amendment standing alone had registered in the previous century. So I think one of the messages for us is constitutional interpretation standing alone is not going to get us what we want as a matter of the progressive Constitution. Organizing and changing who the judges are is going to do more than changing what the theory is, because the theories that we have to litigate with are the theories that the various justices find appealing. And so I find myself, when I prepare briefs in constitutional cases, having to be kind of multilingual, because you have justices who are pure pragmatists, you have justices who are faint-hearted originalists, you have justices who are faint-brained originalists, you have justices who are idiosyncratic originalists. You have justices who are what I call brown originalists, which is the problem with parents involved is not that it was an originalist decision. It was completely an argument about what did Brown mean, and not an argument at all about what did the 14th Amendment standing alone mean. So I think that I go to work every day sitting behind a desk that was John Ely's desk when he was a professor at Stanford. And so I understand process theory. But process theory only gets you so far. what you have to ask yourself is, what does the Constitution mean today? And how do we persuade judges to get out of the way when the Constitution is being interpreted by the legislature in the ways we like? And how do we persuade them to get involved? Because I don't think that constitutional theory is the issue here. There are plenty of constitutional theories out there. I don't think we're going to invent a new one. I'm not sure that we're going to persuade very many people to abandon the theories that they have. And so the main thing that you have to ask is, who's doing the interpretation in some sense, and not what interpretation are they doing? And so I guess I'm becoming, after 10 years of these discussions at ACS, tired of the just plain theory discussions and wanting us to ask instead, okay, what is the problem we're trying to solve at a particular point in time, and what are the tools in our arsenal for solving it? And so that's why I'm looking forward to the panels later in the conference to talk about, well, what are the different theories that explain why we can have a national health care program that doesn't leave millions of Americans to the vagaries of the market or to the hope that there'll be charity? What are the constitutional theories that allow us to try and have an electoral system that gives equal voice to all Americans? And what are the theories that tell the executive branch officials what to do, as well as the courts? The other constitutional moment in the last year that seemed most important to me was, again, not something the courts did, although it's going to play out in the courts, but that is the administration's decision that it can't defend DOMA, and that it thinks that discrimination on the basis of sexual orientation needs greater skepticism before any Supreme Court has announced that, before any Court of Appeals has announced that. And so I think a lot of what we have to be asking ourselves is, how do we change constitutional interpretation by legislators and by executive branch officials, and not to spend most of our time worrying about judicial review itself?
Thanks, Pam. Now we'll turn.
Did I depress you?
Now we'll turn to another person who has been doing the judging since the mid-90s, Judge Diane Wood, who's written a defense of a more dynamic Constitution and tried to defend it against the criticism that it strays from the original intent of the framers. And if you would expand on that, and also touch on one of Jeff's points for the urgency of this moment, too, to be more publicly vigilant to bring these kinds of approaches into the public domain.
Sure. What I wrote, in essence, was that we really ought to be consistent about the Constitution. So I'm going to come back to that in a minute. But I wanted briefly to comment that I think the theoretical discussion is actually a very important one, and whether it's the personalities of the judges or the personalities of the legislatures, not to say that's unimportant, but it's nice to think that there is actually a constitution out there that we are interpreting, and not something that's just an image in the eyes of different people. I entirely agree with what Judge Wilkinson said, that we should test our constitutional theories all the time by the standard of consistency. We shouldn't have one constitution for Roe versus Wade and a different constitution for Heller. We shouldn't have one constitution for Article 2 and a different constitution for Article 1. So I think that if we can say to ourselves, let's change the provision and change the words, is this still a principle that I'm willing to defend, we might be making some progress. And the example I gave in the article that I wrote, perhaps in partial response to the people who think that originalism entails faithfulness to the text of the Constitution, originalism entails careful attention to the problem that the drafters were trying to solve, was the 11th Amendment. Now, if you read passages about the 11th Amendment from the line of decisions that began in the mid-90s and lasted for at least a decade, if not longer, you see things like, well, you don't really follow the text of the 11th Amendment. It's much more important for the propositions that it embodies or for the theory. You know, it makes you think of penumbras, and it makes you think of all sorts of other things that were derided when it came to individual rights. And it seemed to me, choose. If you really want that to be the theory, then we get to have a broader theory of other parts of the Constitution. If that isn't the theory, maybe the 11th Amendment was supposed to address a particular problem about diversity jurisdiction, in which case it would look a lot different in many of those decisions. So I like the idea of consistency, and I think it's a very useful intellectual check on what any particular person, whether it's a judge or somebody else, is about to do. So that takes me to the other argument. I think when you look at the Constitution, you find many provisions, particularly in the original Constitution, that is to say not the amendments, that are empowering of the federal government. The Commerce Clause is a good example of such a thing, certainly the Necessary and Proper Clause. There are other parts in the enumerated powers of Congress in Article 1 that are empowering. And if the Constitution was designed to give that power to Congress, then it seems to me courts ought to respect it. Courts shouldn't strike down the Violence Against Women Act, for example. Congress studied that problem very carefully. It created a big record. And a congressional record is really not the same thing as the kind of record we would expect to put together in a criminal prosecution or even in a civil contest before the courts. So when Congress is using one of these powers that was designed to give it authority to act, then it seems to me courts ought to respect that. This is very much the theory in his books that Justice Breyer has advanced, and I think he makes a strong case for judicial deference to that kind of legislative action. There are, however, parts of the Constitution, primarily in the amendments, but not solely, that are designed to restrain governmental power, sometimes the power of the federal government, sometimes through doctrines of incorporation, or sometimes even just through the logic of the restriction, governmental power as a whole. And if there is supposed to be a restraint, if the government is not supposed to pass laws, for example, that deny equal protection to one group, then that's where we need to step in and see whether a particular act has gone too far. And in fact, majorities, as the Federalist Papers spell out, majorities can run roughshod from time to time with the authority that they've been given. Courts are a legitimate institution to check those kinds of excesses, and I would simply say, again, if you want to go back to originalism, think of what the people who wrote the Constitution understood courts and judges to be. They came from the tradition of the English world. Judges had been independent by that time in the English world for many centuries. They came to decisions that they thought were correct. They had been entrusted with the power to protect the process by which various decisions were made. And I don't think the idea of judges exercising that kind of a check on political power would have been shocking at all to the framers. It's the contrary that I think would have surprised them. So I think, sure, let's be literal. I was accused as a child of being hideously literal about all kinds of things. And I've told people I was fortunate enough to find a profession in which it's actually useful. But having said that, I think if we just look at the Constitution, we see what's designed to empower the government and where are the restrictions supposed to be, we will find that we've got a fairly straightforward test. And I don't think that the framers were fools. They used broad words when they meant broad words, and the example I like to give is nobody worries too much about the titles of nobility clause. Nobody worries too much, really, even about post offices and post roads, although there are a few cases that crop up now and then when someone worries about FedEx. But the fact is, they knew how to be specific when they wanted to do that. They knew how to be broad when they wanted to do that. Let's just follow them.
Thanks, Judge Wood. Akhil Akhil Amar, you have deeply studied the Constitution as a text, and you're one of the people up here who actually doesn't think originalism is that bad of a word when practiced properly. I know you've argued that some of the strongest proponents of it actually don't practice what they preach, Justices Scalia and Thomas, and you'd look more as a model to Hugo Black, who would be, I guess, an originalist, so to speak. If you would just respond to Jeff on those terms, and maybe tell us why, if originalism were returned to more of its core, it might be more helpful.
Thanks, Joan. It's a real honor to be here. So we have a lot in common in this society, in this culture. It's called the American Constitution Society. It would be good if we actually focused on the Constitution. It's what the society believes in. It's what binds us together as Americans. That's what Eric Lee was talking about yesterday. Hugo Black. You see, before there was Mies, before there was Bork, before there was Scalia, before there was Thomas, there was Hugo Lafayette Black, FDR's first appointee to the court, and he always carried a copy of the Constitution around with him. Imagine the kind of person who would always carry a copy. I have two of the Constitution around with him, you know, always, except in the shower or in bed, and sometimes even in bed, but we won't get into that. So this document, you see, and before there was Hugo Black, there was John Marshall, you know, and he doesn't walk away from the text or the history or the structure of the Constitution. He embodies it. And this document, you see, this is what we stand on. This is power. You need to read this, and then you need to reread it and know it better than the other folks. And when you do, you see, our claim is in this group that we are the more faithful interpreters and followers of this. It really does say equal. It really does say the freedom of speech. It really does say birthright citizenship. And this document is not the Framers' Constitution. The Framers' Constitution failed. Enough with James Madison. He died a slaveholder. He never freed his slaves. This is an intergenerational document. It's not a parchment under glass a few blocks from here. And that's even before we talk about the second Reconstruction, which I'm a huge believer in, and that's because this document has Section 5 of the 14th Amendment, and which gives us the Violence Against Women Act, and Section 2 of the 13th Amendment, and Section 2 of the 15th Amendment, which is partly how the second Reconstruction, Pam reminded you, redeems the first. Congress has power. All of those amendments end with the words, Congress shall have power. And the 16th Amendment, you see, it's about Congress having power. Our friends in the Tea Party, they don't believe in the 16th Amendment. They don't believe in the first words of the 14th Amendment. They don't believe in the last words of the 14th Amendment. They got problems with the 17th Amendment. They got problems with this document. We don't. This is what we stand on, and we need to know it. And some of us don't, because we think that's, how uncool is that? That's Hugo, and talk about creating a political a coalition. It's not just about judges. Footnote 4 is about judges. And that's what judges want to talk about. Judges want to talk about two things, judges and judicial salaries, basically. You know? And then after we talk about judges and judicial salaries, they say, well, let's talk about judicial independence too. And so you know, and then footnote 4 is maybe a theory of judges. It's not even a theory of all judges. You know what the theory that these guys are supposed to follow? It's not footnote 4. It's Anthony Kennedy. They're lower court judges. They're supposed to not be overruled by the Supreme Court. So the Constitution isn't just about judges. A lot of things will never get into court. You know, the Libya thing may never actually get litigated. So this is the base. John Lewis, Martin Luther King, they claimed to stand on this, to redeem this, and we should too. It's a liberal document. The framers of the Constitution were the revolutionaries of their era, and the fundamental flaw was slavery, and the House was divided against itself, and it fell. And we call that the Civil War, this House that was divided against itself, and it was reborn in the ashes of that, and that's the 13th, 14th, and 15th Amendments, which are in here, and the 19th Amendment, and that's not the founders, it's an intergeneration, but the Reconstruction generation were the liberals of their day, just as the founders were of their day. They were pro-tax people. The longest section of the longest article begins by telling you 4 different ways you're going to be taxed, but with representation. you know, to the critics of Obamacare, this is a tax. And it's perfectly okay because you don't like it, vote against them. But there's taxation with representation. So the liberals in the founding era gave you the Constitution, and then the liberals of the Reconstruction era gave you the Reconstruction, and then the liberals of the 20th century give you women's suffrage and the second Reconstruction amendments, and we should not be walking away from this document. We should be claiming its text and its history, you see, because yes, some stuff is ambiguous, but how would you know if it's ambiguous without actually knowing the history and the structure behind it? So it really does apply the Bill of Rights against the states. That's not made up by judges. You may say, well, where does it say that, Professor? It doesn't say Bill of Rights. Yes, it doesn't say Bill of Rights, because this document, even in what we call the Bill of Rights, doesn't say the Bill of Rights. Okay? That's in state constitutions, but not in this one. That's what you might notice if you actually read it for yourself rather than rely on what other people tell you here. It doesn't say Bill of Rights anywhere. So, of course, they didn't say in the 14th Amendment apply the Bill of Rights against the states because that would have been an unintelligible sentence. They said, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, and that meant the Bill of Rights. It meant more than the Bill of Rights. It meant unenumerated rights, too, with all due respect, Judge. It meant unenumerated rights, too, of liberal sort and of conservative sort. It meant less than what we call the Bill of Rights to the extent that the original amendments were partly states' rights that don't sensibly apply against states. But you wouldn't know that just by reading the words. You actually, you know, this is power and you got to read it, but actually, I'm going to make a second pitch. You got to read the history behind it. So you should read Jeff Stone's great book about the history of free speech in America. This is a book trying to take you through the Constitution, start to finish. It's called America's Constitution, a biography. This is a book about the Bill of Rights. We have to do work. You can't have power without doing the work. We need to know the history. When we know the history, it's actually on our side. It is not on the side of conservatives who are they're writing books. And these books actually are faithless to the Constitution. They actually don't respect its text, history, and structure. This is a book, Rehabilitating Lochner. This is what they want to do, and they call it Citizens United. You see, that's rehabilitating Lochner, privileging property over democracy. Restoring the lost Constitution, no, this is inventing a Constitution that never was, is not yet, and never should be. And it actually doesn't get the history right. And if Randy's here, I'm happy to tell you, you know, Randy Barnett, if you're, you know, you're coming later on today, where it actually is faithful. Hugo Lafayette Black is, since we talked about the Warren Court, he's the driving force of the Warren Court. He's there way before Earl Warren. And here's what the Warren Court does. It does 6 things, and Hugo Black is there, and Jeff mentioned them. Applies the Bill of Rights against the states. Think about a Bill of Rights case. And, you know, the big ones, whether you like them or not, none of them really are Bill of Rights cases. They're 14th Amendment cases. They're Miranda against Arizona. They're Gideon versus Wainwright, which is a case out of Texas. There's Roe versus Wade from Texas. There's Lawrence versus Texas. A lot of Texas. There's Griswold versus Connecticut. There's Brown versus Board of Education of Topeka, Kansas. These are 14th. So here's what the Warren Court gives us. Incorporation of the Bill of Rights, that's Hugo Black's idea. And he's right about that. He actually gets his history right. There's one person, one vote, and Black is there. And actually, the text of the Constitution doesn't say it, but it actually is in its structure when you actually know how to read it. And they give us broad freedom of speech, because the document really is about that. First, in the original First Amendment and the 14th and thereafter. And rights especially of indigent criminal defendants and a fair criminal procedure, and getting rid of prayer in the public schools. These things that the Warren Court does, they're actually not made up. They come from, and Hugo Black is there first, so before Bork, before Mies, before Scalia, before Thomas, there's actually liberal originalism, there's Hugo Black, there's John Marshall, and they should really be, it seems to me, beacons for us today. So one thing that the ACS and the CAC, the Constitution Accountability, what do they have in common? They have in common the Constitution, its text, its intergenerational history, its deep structure, its liberal essence. Thank you.
I'm going to ask a couple questions just to prod the discussion, but I hope everybody jumps in. The one thing that strikes me sitting here, hearing such sensible talk that I know has been out there for a long time, seeing a room full of people, knowing that Jeff has been writing about these themes for many years. Diane Wood's essay appeared many years ago. Stephen Breyer has certainly written many books on this theme. Why has the traction been in the other direction? You had a battle cry of sorts, Jeff, about how progressives are on the defensive rhetorically. They're not getting their message out. And it seems like, given what you said and even what Judge Wilkinson said about sort of the wasteland that we're in some ways in terms of ideas about constitutional interpretation, that things are actually going in the opposite direction. Why do you think that is?
Well, first of all, marketing. The idea of something like originalism or judicial restraint is just easy, it's simplistic, and people can sort of think they understand it very readily. Second of all, they've had presidents who have actually, as part of the marketing, endorsed those views in a very aggressive way, which gave both credibility and visibility to those positions, whereas we've not had the equivalent on the progressive side. Third, I think it's important to understand that activist judicial review generally means telling the people they can't do what they want to do. And therefore, it's much harder to sell activist positions than it is restrained positions. And so, for the most part, I think what's happened is that conservatives have been able to say, we just call balls and strikes, we just apply the Constitution as it's written, you know, we apply originalism, we're restrained, which means basically we're going to let you guys do what you want to do. Right? We're not going to interfere. And to make a strong argument on the progressive side, which historically, at least since 1954, has tended to mean activism. Not always, certainly. During the Lochner era, it was flipped. And today, it's increasingly flipped. But during most of this period, progressivism meant courts should be muscular, they should intervene, they should tell you what you can't do because we know better. That's a hard sell, right? Plus the fact that we have not been able to articulate what it is we believe in about how courts should make the decisions in a way that is easily conveyed to the public. And so it's therefore caricatured as, you know, well, trust us, we'll do the right thing by you, you know, we're lawyers, we're judges, we can tell every state in the country how they should run their business because we know better. And even though, as we've heard here, there are theories underlying progressive activism, they're not easy to explain. What Akhil says, for example, may be true, but try explaining that to the American people in a way that's compelling and where you're telling them.
I think I just did.
No, you did it to this audience.
I go to other audiences and I get the same reaction. But I stand on the Constitution and not fancy theories about adjudication.
Right. Well.
But you know, Jeff.
Okay.
Go ahead, Diane.
Go ahead.
Judge Wood.
Yeah, you call me Diane. I think there are really two things that have gone on. One of them is a function of broader political movements that has resulted in political power on the part of a more conservative, you know, the Republicans have won the presidency a lot of times, and sometimes that's been for reasons, much as we love ourselves and our own agenda, that have really not had a lot to do with us. People have voted because of national security issues, people have voted because of the economy in various ways, people have voted, you know, you think of what have been the salient issues, you know, during the presidential campaign of 1980 when Ronald Reagan won. Well, they'd throw in judges every so often, but it really wasn't that. So I think part of it is broader political movements. Part of it is a backlash to two big legal developments that were strongly disliked by many people. One of them was affirmative action and the other was abortion. It galvanized support for candidates who promised to oppose those things. And so that led to the appointment of judges and the election of legislators who were committed to a conservative ideology. Now, that doesn't mean that these judges and legislators were following, quote, the original Constitution. I think that they weren't, actually. But it certainly is what has led us to have more and more decisions that are fairly strong headwinds, and I want to take slight exception. I think there were a lot of decisions that told people you can't do what you want to do, but when you think of not just the Violence Against Women Act, but when you think of Congress's effort to have the age discrimination laws apply across the board, the disability discrimination laws, and of course the giant elephant in the room is Citizens United. It's election finance laws. It's a subject of great concern on both sides of the aisle, and the court decided that it really couldn't stand, at least in the form that it was presented in Citizens United, and I don't know if in any form. So I think that these are broader political movements, and it is people who are exerting a fairly conservative vision of policy.
Joe,
You know,
can I
Sure, of course. Yeah.
Everybody's afraid of something in terms of a specter, and I know Jeff has this view that conservatives are getting all this traction and are making all this headway. You know, that's not so much my fear. My fear is that we do have these very open textured provisions, but far from granting a green light to judges, they seem to me to flash an amber light, or in some cases a red. And the three provisions that trouble me most are the substantive due process clause, because process seems to me to suggest a certain allegiance to procedure rather than the creation of substantive rights. We've already talked about Roe in some of the other cases. The Ninth Amendment concerns me a great deal, and if you listen to conservative libertarians such as Randy Barnett and others, they're for recognizing a profusion of rights under the Ninth Amendment. The Privileges or Immunities Clause troubles me a lot because it's so open-ended. These are pristine clauses. They haven't been interpreted, and they're lying there, waiting for the judiciary to pour all kinds of subjective content into them, as you saw the majority do in the McDonald case, or at least Justice Thomas with respect to his Privileges or Immunities decision. And you can say what you want about Citizens United and parents involved, and conservatives will come back and say, yes, but parents involved and Citizens United were at least linked up to the core political speech in the First Amendment and to a history of judicial decision-making and everything under the Equal Protection Clause. Whatever else you can say about them, they were not tied to those three wholly open-ended provisions of substantive due process, privileges or immunities, and the Ninth Amendment. So there's a real threat to judicial restraint, I think, from that quarter, and I also think that originalism provides a real threat to judicial restraint. It's open to subjectivity. Very often there's precious little evidence as to what the framers ever thought. Other times there's way too much evidence going in all kinds of different directions. And judges are able to select from this plethora of evidence which way they want to go. And finally, with respect to originalism, judges just aren't very good historians. And they're trying to construct a history on very difficult things with 100 other cases begging their attention at the same time. And you've got judges trying to do within the compressed course of a single term a major historical project that would take professional historians decades to accomplish. I just want to say this, because this is so heartfelt with me, that really from right and left, the tradition of restraint is under siege. We once had it. We once had it with people like Lewis Powell, and we once had it with people like John Harlan. To a degree, we had it with someone like Hugo Black. We certainly had it with Learned Hand. We had it in important respects with Brandeis and Holmes. And we are going away from that. We are moving away from the grand tradition of restraint that our greatest Supreme Court justices have embodied in times past. Now, that's not to say that every vote they cast was an exemplar of judicial restraint. Lewis Powell voted for Roe v. Wade. He was in the majority in that case. John Harlan voted to strike down the Connecticut statute in Griswold. So it's not an inflexible reaction, but I do urge you to examine the historical roots of this magnificent tradition of restraint, and please understand how far both right and left have strayed and wandered from it.
Thank you. Pam, your job takes you to many audiences, students before the justices, forums like this, in your writings. Is there a problem with translating the kinds of concerns that have been articulated by Judge Wood and Judge Wilkinson to the public who elect people and then who follow the judicial nominations and might be able to put pressure on the Senate when we have candidates come up, such as one of your co-authors, Goodwin Liu?
I think it is hard, because one of the things that's happened is the entire nature of the dialogue now is so heated. It's so soundbite oriented, which goes back to something that Jeff was saying. People are so angry and so fearful about a number of things. The football coach Vince Lombardi used to say, "Fear makes cowards of us all," which, if you think about it, doesn't mean very much, but it actually gets across an important point, which is it's very hard to talk to people in a society when people don't talk anymore about profound issues, right? You have to be in a society in which people talk about mundane issues with people who are not like them before they can get to a society when they talk about profound issues. That's the point, for example, of Robert Putnam's book, Bowling Alone. It's the point of Cass Sunstein's work on the Daily Me, in which people only talk to themselves and people they agree with. So I think the translation is hard, and I think part of the reason why we on the left have found it harder to talk about. It's much easier to criticize things than to give a constructive account. That's why, because there was a generation of liberal triumph in the Warren Court, it's then easy for conservatives to critique that, because it's always easier to find the flaws in things. That was a little bit of the point of the panel yesterday when Eric Liu was talking about, what do you learn as a lawyer? You learn how to break things down into little pieces. And so it's much easier to break down other people's theories into little pieces than to give the affirmative version of your theory, especially if you have 25 seconds to do it in front of an audience of people who have been worked up into a lather of rage about what's going on in the society around them. The places where you see the most progress being made in people's constitutional understanding, I think today the place where, if we were to talk about the triumph of the left over the last generation, it's issues of LGBT rights. Mm-hmm. That is, we have moved from a society, when I clerked on the Supreme Court in 1985-86, the court decided Bowers against Hardwick, and I don't think you could have found a single justice who would even have thought about issues of same-sex marriage as a matter of constitutional law. Today, we are on the verge of a real triumph on this issue. If we don't win same-sex marriage as a matter of fundamental popular constitutional understanding in the next couple of years, we will in the next generation. People will look back 100 years from now and wonder what was going on here, right? Now, that's a victory that's been achieved not so much through small constitutional arguments, but through the fact that people came out of the closet and their neighbors started to know them and think, why is it that that nice couple down the street can't get married? Why is it that we restrict marriage to opposite-sex couples? Now, those things are going to change, but they're going to change mostly because people have conversations around the water cooler, in the bowling alley, if anybody is not bowling alone these days, and the like. It's not going to be because law professors get up and give speeches about it.
I'm wondering if maybe, given what you said about the gay rights issue, if this can only be articulated through specific concrete dilemmas. When you think of the Obama administration, that there were some suggestions that it hasn't been strong enough on these progressive ideals coming in to say, we're not going to argue for DOMA, or that moment that sort of brings a lot of these themes together when the president stood up and criticized Citizens United at the State of the Union, where you just don't have those kinds of moments much, but it is the main merging that you have in a public forum that might resonate with people.
Well,
Akhil?
Pam, I think, offers an answer to Judge Wilkinson's concern about judicial activism. She's offering a vision of popular constitutionalism. It's a vision very much championed by the dean of the Stanford Law School. So maybe there's
who pays
something.
my salary?
But Larry Kramer isn't making it up. The first three words are "we the people." The words "the people" appear more times in the first 10 amendments than any other phrase. If you want to know what the rights of the people, the unenumerated rights of the people in the 9th Amendment are, ask the people. If you want to know what the privileges and immunities of citizens are that can't be enumerated, because there's so many of them, they're infinite, why don't you ask ordinary citizens what they think their privileges and immunities are? And that has changed over time. And that is the way in which earlier generations brought us into the conversation. And it isn't just about judges, you see, it's about, so let's go through the list. But this is the problem. Just with focusing just too much on judges in a vacuum. So I do want to go through the list of these supposed sort of heroes of restraint, because I want to say yes and no to this list. So we have Oliver Wendell Holmes. That's basically a big Harvard con job. And Oliver Wendell Holmes doesn't believe in, if you want to reimpose slavery, he's for it in Bailey versus Alabama. And freedom of speech, for most of his life, he's not, and Jeff will confirm this, he doesn't really believe in robust freedom of speech, and even at the end. And if you want to sterilize people, 3 generations of imbeciles are enough. The 14th Amendment does not enact Mr. Herbert Spencer's social statics. Yes, but Mr. Justice Holmes, what does it enact? You see, and he doesn't offer a vision of that, so he can't be our hero. Learned Hand, another Harvard con job. He doesn't believe in applying the Bill of Rights against the states. He criticizes Brown versus Board of Education. This is sort of, restraint on steroids of a sort that we in this room cannot, quite abide. John Marshall Harlan, well, of course I'm going to like him because he's got John Marshall in his name. I like both of them, in fact. And the second one was very restrained, and I don't see Griswold versus Connecticut as some big exception. The law in Connecticut was a really weird law. He says at the end of his opinion in Poe versus Ullman, which is incorporated by reference, conclusive, in my view, is the fact that no state has ever done this. This is really out of sync. This isn't what ordinary people understand their daily lived rights to be, and that's changing on gay rights, and that's changed on the death penalty, and doctrine at its best often on these things does look to the people, and since you mentioned Hugo Black, I'll say amen to that too. But that's a vision in which judges aren't just looking at what other judges have said previously, but looking at Pam's social movements, at we the people.
Well, Akhil, you're really giving some very good, you're really going after some very good people, it seems to me, in a one-sided way, because you're talking about all the things where they restrain themselves that they shouldn't have restrained themselves about. Now, Akhil, suppose they hadn't restrained themselves in a number of instances. Think of what would have ensued. Think of what a judicial hegemony we might be under. And I'll just to take one example, for example, in cases like Dandridge v. Williams and San Antonio versus Rodriguez and Lindsay v. Normet, the activists of that time were trying to transform the nature of the American Constitution from a brake upon a government to a series of positive entitlements. And that was stopped in many instances by the people whom you are now criticizing for being excessively restrained. And I'm asking you to realize how many bullets we dodged because of these justices who exercised restraint. Do you really, I mean, Holmes didn't win his battle in Lochner, but his dissent there, it seems to me, set up and set the foundations for the Roosevelt court in the late 1930s and early 1940s by giving restraint a great cachet. So when I listen to you go after these people, I just don't think that you're giving them their proper due.
Well, we need to know when to be restrained and when not. And restraint across the board, which is what actually Holmes generally practiced and preached, isn't very attractive. So I don't think this book rehabilitates Lochner. It's a book by David Bernstein, a libertarian guy. It doesn't rehabilitate Lochner, and thank God for that. But it does debilitate Holmes, and it actually shows that's not so Holmes and Hand really can't be our icons going forward because they don't believe in applying the Bill of Rights against the states or robustly protecting the Bill of Rights. So that's why I like Hugo Black, because he actually understood, and he got some things wrong. I think not understanding that electronic searches and seizures were just like ordinary physical search. That was a little late in his career, and he ossified a bit. But he embodied both restraint in all sorts of situations and principled defense of core constitutional values, and so that's why I invoked him as, and John Marshall Harlan, who was more conservative sort, wasn't Holmes. He does strike down a ridiculously intrusive upon liberty law in Griswold. And he's very deferential. He affirms robust speech.
Which your friend Hugo Black wanted to uphold.
Yeah. So
no one's
Jeff,
perfect.
Do you want to jump in? Stop talking about dead judges.
Yeah,
I know.
In fact, I just want to give one statistic. I'd love to have Judge Wood and Jeff and Pam jump in, but one of my least favorite stats that I read recently involved some polling by the Pew Research Fund during the Elena Kagan hearings. And as many of us were writing about how she would change the Roberts Court, they polled to see whether people knew who the Chief Justice of the United States was. They gave four names: John Roberts, Harry Reid, John Paul Stevens, and Thurgood Marshall. And only 27% could name the Chief Justice of the United States. So
Was
people,
this a normative or a descriptive?
Anyway, you want to jump in, Jeff, on the...
Yeah, I mean, there's several different themes going on here. One of them is, what does the Constitution mean?
Yes.
And the other is, how should courts enforce the Constitution? So that's the question I was addressing at the outset, the latter.
And there's a third one, which is, how does the public understand the message?
Right. But I want to, because of the exchange between Akhil and Jay, I want to focus on the court issue. And what's clear here is that everybody likes activism sometimes. Even Jay likes activism sometimes, though he won't call it activism. But you like certain decisions. You like Brown, right? Okay, so that's activist. I'm sorry. That's not restraint.
And Hand criticized Brown famously in his lectures.
Right. So everybody likes activism sometimes. And the question, though, is we also don't like activism other times, when it's usually in the hands of people who abuse it, right? But the question is, how do we know the difference, right? Is there any way to know when activism is justified and when it's unjustified, and to have a neutral, objective, fair-minded way of critiquing that so that we can evaluate it? Because if we can't, then it may be Jay's right. If we really have no way of constraining judges from using activism to pursue their own ends, period, then it may be that judicial restraint across the board is better for our democracy. So the question is there some way to figure out, in a persuasive manner, when judges should be active and when they shouldn't?
And
So
Caroline
Jeff,
Product.
I just wanted to say, I think, you use the word activism as though we actually know what that means, but it might mean at least a couple of things I can think of. It might mean a view of the proper role of each of the three primary branches of government that gives too much room, say, to the judiciary and not enough room to the other branches of government. It might mean the practice of judges, when looking at vague provisions of the Constitution, like cruel and unusual punishment, of pouring too much content into them, of taking them too far. Or it might mean that maybe this takes me back a little bit to the first, but there's some provisions of the Constitution, like Section 5 of the 14th Amendment, that give Congress power. And if you think of cases like City of Bernie, it might mean judges giving not enough power to Congress to define what falls within that scope. And so I think the type of activism you're talking about, each one of those yields a somewhat different broad
Because by
debate.
activist, what I mean in this conversation is judges exercising the power to hold laws unconstitutional in situations where it's not obvious to people on all sides that it's unconstitutional. So that's what I mean by it. It's about judicial power.
And Caroline Products is a great first start, and hats off to John Ely, whose wonderful book I forgot to bring up here because I just forgot. But remember John Ely has real questions about women's rights, because women aren't discrete, nor insular, nor a minority, you know, in sort of a Voltaire approach. He has problems with privacy jurisprudence. He has problems with Roe versus Wade, very famously. So Caroline Products footnote 4 might not be sort of a silver, whereas I would say it really does say equal. There really was a 19th Amendment, and actually in 30 seconds I can prove to you that the framers of the 19th Amendment believed that women should be voting equally on juries, just as they should be voting equally for legislators and in the legislature and in referenda and in primaries. So in fact, since you mentioned women juries, there is just demonstrable 30-second soundbiteable history on the 19th Amendment on that.
Can I?
Yeah, go ahead, and I'm going to ask something about
I want
campus.
to say, so to pick up on what Jeff was mentioning, footnote 4 of Caroline Products, and Akhil was mentioning footnote 4 of Caroline Products in connection with John Ely's book. My problem with footnote 4 of Caroline Products is really it was a very, very decent footnote for its time and place. It has become a victim of its own success because Caroline Products was an injunction to the judiciary to intervene in certain instances. But all those instances that Caroline Products saw as constitutional have now been the subject of extensive statutory exercises. We have statutes in place that protect vigorously against racial discrimination. We have statutes in place that protect vigorously against gender discrimination. We have statutes in place that protect vigorously against age discrimination and against disability discrimination. And what I ask you now, if we're going to talk about Caroline Products, isn't this whole area statutory, and doesn't this underscore the wisdom of leaving things to the political process, and that the political process does occasionally move in the right direction, as it has with these anti-discrimination statutes? And isn't it a good thing that to some extent Caroline Products is obsolescent?
So when the Fourth Circuit struck down the Violence Against Women's Act in Broncala, that was an outrage, and the Supreme Court upheld that in Burney, and they should not have done that because it really does, in what became the Morrison case, yes, on appeal. So, and Congress really does have sweeping power to affirm civil rights and human rights, and courts shouldn't have invalidated that on any theory. Shame on the Fourth Circuit.
Let's not get personal about circuits here.
Sometime, Akhil, I voted to strike that down. Now, sometime you and I are going to have to get together for a very long drink.
Right.
And talk about that.
Yes, Pam earlier described herself as being between two warring, divorcing parents, and I think I'm finding myself in that role. We have several questions, but we have just a minute or two before we go to all those questions. I just want to ask about, especially to the academics, about what's happening on campuses, because you know ACS has so many chapters out there now and has tried to make so many inroads against the Federalist Society in many ways. And I was struck by something that Justice Ginsburg said to me recently when we were talking about the force of Justice Scalia. And she said when she was teaching in the 60s and 70s, the left controlled everything on campus in her mind. And she said now she gets resumes from students who premier the Federalist Society, and that things have so changed. And I was wondering, just in terms of, Jeff, your emphasis on communicating to all the public, but especially to law students, has something evolved on campuses that maybe deserves addressing in a more heightened way?
Well, I mean, I think progressive law students are desperate to have answers to defend what they believe somehow to be right, and that perhaps except at Yale, they don't have those answers. And so when I go around and talk to ACS chapters, what I constantly find is this sense of in my gut, I know that I like certain decisions of the Supreme Court. I know I have certain views about the law, but I don't know how to really answer the Federalists. I don't know how to address them on their terms effectively. And I think ACS really needs to figure out how to provide students with that ammunition, both to educate them and to enable them to carry that argument forward, because that's the future of the profession.
Right.
Great, thanks. We've got just 15 minutes left, and we're going to try to stay on schedule. And we've got about a dozen questions here, and I'm just going to go through them, starting with some of the more specific. And Pam, I thought I'd start with you on this. How do we have a popular discussion of constitutional law when many of us denounce those who defend DOMA as unworthy of debate? First of all, do you agree with the premise? And then
I'm not sure I understand by do I agree with the premise. Do I think DOMA is a debatable statute? Or
how to have a popular discussion, how to even engage in it, when many of the people in the audience and up here, would denounce those who defend DOMA as unworthy of debate?
Oh, no, I think the people who defend DOMA are worthy of debate and crushing them like bugs substantively. Do I think that we can have a debate about whether the federal government should be defining marriage? Yes, I think we can have that debate. I think we will win that debate. The debate that I find it hard to have is with people who make a kind of natural law argument that says, God has told me. I mean, I had one of these debates a couple of years ago with an academic who basically just said, God has told me there's really only one way for there to be a family. Well, I can't debate that person because, of course, my God tells me something different. And my God is the Old Testament God. He was here first. First in time, first in right. And there's my... No, I'm prepared.
You don't believe in overruling?
No, I'm prepared to have a debate about these issues. I think I can win a debate about these issues. It's not that I don't. It's not that I mean, they're debatable in a descriptive sense. I think that when you have a serious debate about them, we'll win the serious debate. But the lesson, I think, of this panel in some ways is we might not even be having this debate if 10 years ago the popular movement had made it clear that no president should have signed this law in the first place because this law undermines fundamental principles of equality and fundamental principles of federalism. And then we wouldn't be having this debate at all.
Here's another one on a concrete issue. Please address the notion of corporate personhood and the rights it affords and whether this doctrine can be slowed, stopped, or reversed. And in parens, the writer puts, or should it?
Can I just give a little bit of an answer to that one?
Sure.
Thanks. So I think this is a legitimately hard question. I have a piece coming out in the Boston Review in the July issue, so it'll be online and you can kind of see it. But I don't think the real argument here is, do corporations have rights? They have to have rights in our system. Most of the media is corporate. Exactly. If we don't believe in First Amendment rights for media corporations, then we won't have freedom of speech. If we believe that the government can just seize property because it's owned by corporations without having any due process, our whole economy would theoretically fall apart. So I don't think the argument is, do corporations have rights? In some sense, of course they do. The question is, should corporations be regulated differently than individuals with respect to those rights? That's the hard question. I think that I think Citizens United was wrongly decided, but not because corporations should have no rights to participate in the political process in any sense, but because the way corporate law operates, you have a principal agent problem and the like. So I think that we are not going to be able to make a credible, persuasive argument to people that corporations should be stripped of all rights in the U.S. legal system. That has no traction at all. The argument has to be more refined than that.
Judge Wood, would you like to jump in?
Yeah, I just wanted to add that I agree with a lot of what Pam said. Corporations, if you look at the Citizens United decision itself, are described in a sense as just one kind of group of people, and they happen to be structured under various state corporate laws, and I think that's right, but then we need to look at the details of how groups of people are regulated in different forms. If that particular group of people were called a union, and the union wanted to have political speech, there would be rights under a long line of Supreme Court cases, Beck, et cetera, Abood, for people who didn't agree with that message to withdraw their money from the amount that funds that message. Well, why doesn't that principle work for shareholders? maybe let the corporation speak all at once, but to the extent that there are shareholders who don't want to take part in it, they get a bigger dividend or something. There are ways of understanding that this is just one more group, and if you just start thinking of it as groups, you may find that there are more nuances that need to be brought in.
And I agree, they're brilliant. And for those who are interested in what progressive campaign finance really would look like, because McCain-Feingold was not great shakes. Remember, it's McCain. Okay, and he gets up on the floor of the Senate and said, there are all these people running attack ads against us, as if that's an argument to vote for the law. You know, dude, the First Amendment. You get to attack senators. If you want to see what real progressive campaign finance would be, because we have a vision of the Constitution as property competing with Constitution as equality, because voting, you know, and speech partake of both. Take a look at Bruce Ackerman and Ian Ayres' idea about voting with dollars. It's a very interesting idea in which sort of everyone, in effect, gets a kind of voucher from the government, $10 or something to contribute to the candidate of their choice. It's a way of bringing more people into the system. It's an egalitarian vision of campaign finance reform that's quite interesting. I'm not saying it's, you know, it has no problems with it, but it's a vision of progressive campaign finance reform.
Thanks. Yeah, and then we have a specific question for you too.
Okay. All right. On the corporation as a person, many of the, remember this was not a ban, this did not relax the ban on corporate contributions to candidates. It simply talked about corporate expenditures here, and many of the restrictions on corporate expenditures were passed long before the internet. And aren't we in a free speech world now with cable television and blogs and the rest, where there's just a profusion of voices, and where corporate speech is less to be feared than it once was. And I think Pam points out it's not just those, quote, big bad corporations that have been unleashed on the political process. You're talking about a lot of nonprofits. They're going to be from the right and from the left. And we're talking about labor unions getting into the act as well, and you know, where the political marketplace of speech is concerned, sometimes it's good to have the more the merrier, as long as the source of the speech is available and disclosed. And one of the things we've got to worry about now at this point is regulations of elections becoming more complex than the Internal Revenue Code is. I mean, we're going to have really significant overhead added to campaigns, and it's going to work to the detriment of disadvantaged candidates who aren't going to be able to follow and comply with all of this arcane mountain of laws and regulations without hiring a battery of legal counsel. And I just don't know that's the way we want to go.
Judge Wilkinson, can I get you to briefly answer one more before we enter our lightning round with just 5 minutes left? This one refers to a ruling from the Fourth Circuit that has been mentioned several times up here today, Broncala versus Morrison, which I believe was in 2000, involving the Violence Against Women's Act. You seem to say there is, quote, good judicial activism and, quote, bad judicial activism, and that the Fourth Circuit's decision was good activism. Please explain that view in the context of your advocacy of restraint and deference to the legislative branch.
You see what you got started, Akhil?
in 2 minutes.
I think Akhil wrote this and handed it over. Yeah.
That's one of your students, Akhil. That's a plant.
Thank you.
I think that law went very, very far into an area that had been a historic bastion and refuge of the states, which was a domestic relations area. And this is one of the last areas of that the federal government hadn't extensively gotten into. And it was difficult for me to see the connection between those individual instances and the term commerce. Now, you know, lest you think I'm an activist, when the Endangered Species Act came up several years later, and a great many of my colleagues wanted to strike down the Endangered Species Act, I blew the whistle on it, and I said, no, absolutely not. The Endangered Species Act is a monumental piece of environmental legislation. Environmental legislation concerns interstate problems. There's a definite connection to commerce here, and that was a bitterly fought thing within the Fourth Circuit. I fell on my sword to uphold that statute in the name of judicial restraint, and I'm mighty glad I did.
Thanks. This one to Professor Stone. You gave a persuasive originalist critique of conservative activist decisions like Louisville Schools and Citizens United. So why keep knocking originalism, and why not just show why the Framers' Constitution supports progressive outcomes?
I think that it can, and it does, and I think Akhil makes good arguments to that effect. And as I said in the talk, I think that understanding the framers' aspirations and goals and meanings is a relevant and important part of constitutional law. But I also think it's so open-ended as a methodology that it has no boundaries. And that in the hands of one person you get one result, in the hands of another person you get another result. And I do think there's a need for some constraint on judges on both sides, and that therefore the simple embrace of originalism basically says judges can do whatever they want. And that worries me a lot.
This is a slight follow-up on that one. If Heller and Roe are the result of inappropriate activism, why isn't the same true of Brown, Miranda, and Reynolds v. Sims? Are they more accurately based on language in the Constitution?
I assume that's actually for Jay, because he's the one who...
I think Heller and Roe, I think Miranda, and I've long believed Miranda was located squarely in the privilege of against self-incrimination. I think Gideon versus Wainwright is located squarely in the Sixth Amendment right to counsel. I simply don't have that similar impression that there's a comparable textual hook with respect to Heller v. Roe. Heller and Roe, I think Roe is far afield of text, structure, and history, and I think Heller at this late date took a very ambiguous history, and on this point I agree with Jeff. I think that the 5-4 breakdown in the case was deeply unfortunate, because it seemed as if those judges who were more supportive of gun rights voted with the majority, and those who were less supportive of gun rights voted in dissent. And so I wouldn't equate them in any way, shape, or form with decisions that vindicated the rights of African Americans to an equal opportunity in this great country of ours, or that vindicated the privilege against self-incrimination and brought and helped to mitigate what were very coercive custodial practices.
And going forward with our last one, someone writes, Obamacare, constitutional?
I pass.
I was
easily and obviously, and you can freely download a piece on ssrn.com that I posted a week ago on this. There are 6, count them, 6 different arguments for congressional power. It's a tax, it's a regulation of interstate commerce, 3 ways, it's a tax equivalent, and it's also, and this is the only one of the 6 that's even at all edgy, because those 5 are just not just text, history, and structure, but binding precedent on every lower court judge, easily and obviously. And the 6th, which is edgier, is it's a civil rights, human rights law. If you believe, as I do, that Congress has sweeping power after the Reconstruction, I'm with Jay on Bracala as the Violence Against Women's Act as going a little bit far, too far arguably, as a regulation of interstate commerce, because that law wasn't obviously regulating an interstate issue or an economic issue. I think it was an easy human rights law. Section 5, 14th Amendment law. Section 2, 13th Amendment law. It was an inadequate appreciation on both the Fourth Circuit and the Supreme Court of the deep powers of Congress to regulate human rights and civil rights. Obamacare, I think, health care can be understood as a basic civil right. The reason that's edgy is precisely because the Supreme Court in City of Bernie did side with the Fourth Circuit on that, and so that argument is just based on text, history, structure, Hugo Black stuff, and not on precedent.
Judge Wood? Can you be drawn out on this? No. I thought I'd try. I think the Seventh Circuit is one of the circuits that doesn't have one quite yet, but you might.
At the moment.
Yes, right. Well, thank you all so much. Just a couple follow-up things. First of all,
Applaud you.
thanks so much, Jeff, Pam, Judge Wilkinson, Judge Wood, and Akhil. I think everybody is more energized on the subject now. Just one last thing. In order to ease the transition to the next set of panels, I want to just tell you your options. There are several breakout sessions immediately following this. One is Judicial Independence in Peril. That's in the South American room. Another is Dodd-Frank and the Future of Securities Litigation in the Congressional room. Another is Sentenced for Life, Considering the Collateral Consequences of Criminal Convictions. That's in the Federal room. And finally, Privatization, the American Worker and the Role of Government in the Senate room. And volunteers will be on site to direct you to those locations. Thank you all for being here, and I hope you enjoy the rest of the conference.